introduce everyone to Clarence. Clarence is one of the veterans in crypto. There are very few people in the world who understand crypto regulation and how to help projects. And Clarence is the director at Bayfront Law. Clarence will briefly go through a small talk he has prepared, covering how to look at, as a founder, at what point you consider legalities, how is it different from a traditional fundraise, and touch upon some of those aspects. So welcome, Clarence, and over to you.
Yeah, thanks. Yeah, thank you so much. Yeah, okay. So I think we've been around the space for a while, and we speak to many startup founders, and I think that the questions and issues generally fall into the similar categories. So okay, so I think first
so I was basically discussing the difference between like regular regular like securities fundraising versus crypto fundraising, right? So the main point really is that because you are now able to sell these tokens to the world at large generally, it also comes with a certain set of trade-offs, and the trade-offs are basically in the area of like securities laws, tax, KYC, AML compliance. So I think one of the biggest issues, right, really, it's regarding the whole hoo-ha around the world regarding whether a token is a security or not. So I think many times when projects try and get more and more creative with like the tokenomics, how they want to reward users of the network, they actually risk triggering some of these securities laws. So I think like for example, if you are rewarding a user for like you reward them with a share of like network fees, or like you give the user some sort of ownership stake in some sort of assets. So usually that's where the issues come start to arise. And I think the takeaway to focus on here really is that when you are considering like tokenomics, whether a token is a security or not, one thing is to make sure that before you, it is not that you cannot give out rewards or incentives to your users, because that's what it is all about, right? This whole blockchain this whole like blockchain industry. But the main thing is that you need to ensure that when you give out these incentives or rewards, you got to make sure that it is not a passive type thing. You see, so in a sense, you got to structure the tokenomics in such a way that before you pay out any sort of reward, you make the user work for the reward. You see, so like for example, like if you look at like why is like POS mining okay? POS mining is okay because the users, they are not actually getting rewards passively just by holding tokens. The justification for that is that the users, they are actually they are actually assisting to secure the network, and that's why they are getting paid for this kind of services. You see, so I guess it's a similar kind of concept that you can apply to many of the DeFi protocols as well. So if you look at like like Curve, I guess Curve, why Curve LPs get additional Curve is because they are providing the useful service of providing liquidity. So this service and work can be quite broadly and quite generally defined, but you got to try and at least find something to peg it to before you reward your users with additional tokens. Yeah, so I mean the stuff can be like small stuff like even like tagging a friend, helping with marketing, providing liquidity, participating in governance. Basically, as long as there's some sort of work there, then yes, I can say that you have a much lower risk of triggering this kind of securities loss inadvertently. Yeah.
Great. So Clarence, one question that a lot of people have is, in the traditional startup, we have a private limited company, we have a term sheet. If it's a seed stage, it's either a convertible note, and then at the valuation, you raise money. There are different classes of shares, different series of rounds. But when you look at crypto, there may or may not exist a private entity, right? So how, if I'm a founder, I have an idea, I may or may not be technically savvy, but I'm building a project now, right? I'm say 1 month into the project. At what point do I start thinking about the legalities of it, and how would it be at a very high level different from a traditional startup when I'm especially wanting to raise my first check?
I see. Okay, so now that we go into the structuring aspects, right? The most obvious point, one of the most basic structures in the market out there, right, really uh is that there usually is an offshore company that issues and sells the tokens, and that will be alongside an onshore company that will basically carry out the development work. So these are really some of the basic pieces for structuring that need to be in place regardless of what kind of project that you run. And see, so like regarding where to site the offshore entity, where to site the onshore entity, I think the answer is that you actually need to consider this very early on in the project. Basically, before you raise your first check, regardless of whether it's an equity check or whether it's a token check, you actually should get the structure in place already, because this is what causes the liability to crystallize. The act of selling something is the act that causes liability to accrue. So at that time, you will want your the proper structure in place to provide more protection. Yeah. So,
Got it.
yeah.
And this entity will be the one that issues the tokens, right? Through what vehicle are these tokens issued? Because most likely you're not yet live.
Yes, correct. So this offshore entity will be the vehicle that issues a token. That is the basic setup. So how you want to but in the market, right, there are many different solutions for how projects want to hold the offshore entity. So like, for example, right, there are projects that they want to move towards maybe a more DAO-like structure, or basically they want to decentralize the governance a bit more. They can have this vehicle being held by some sort of foundation type entity. But again, there are different pros and cons to the different structures. So the main one is that once you set up some sort of foundation type entity, right, then by definition you actually give up control over the project. So this may not be that suitable for like the super early stage projects out there in the market. Yeah, because if you follow like stuff like like the Tezos kind of litigation, right, a lot of the problems were caused because they had set up like a Swiss foundation. There was like an independent board of directors, there's independent trustee, and then because of that, there were some decisions that I guess the independent governors didn't agree with, or so that's why there were lawsuits. They were getting stop orders and all that. Yeah, so this is on the choice of entity itself. So I would say that for most projects in the market, right, the most basic structure is just get some entity set up somewhere in like the British Virgin Islands or Panama, and use that to sell the token for the selling side, for the raise side of things. And for the spending side of things, you can send the funds back onshore via internal agreement. So the spending can be done, via like, for example, you have an onshore Indian development company, or if let's say you want to set up the development company in a more neutral jurisdiction to create more distance, like Singapore, Hong Kong, Dubai, they are all very common options for this development company.
Got it. Great. Thank you so much,
Yeah.
Clarence. Do you have any more thoughts to add on this topic before we dive into a 10-minute Q&A session?
Yeah. Okay. I saw a question in the chat group regarding the choice of Switzerland as the foundation, right? I think the answer to that really is okay, because there are a whole range of jurisdictions available out there, and there are different trade-offs. So I think Switzerland is on the extreme end of the spectrum, actually. So basically, for Switzerland, they are basically the jurisdiction with like the strictest laws, the highest cost of setup, the most independent governance. So there's independent trustees, there's independent board of governance, independent board of directors, independent trustees, and there's probably also things like like compulsory audits and different checks and balances. And so I think some projects, like what we see is that the projects that go there tend to be like the really, really major ones, like, I think Cardano is there, Ethereum is there, this kind of really major projects. But the thing to take note also is that for many of these projects, they didn't actually start there. You can actually start with a simpler structure, and then over time, as you decide to create more structure, create the more permanent kind of governance structure because the founders want to step down, because they want to step down, you can actually shift the structure towards this kind of more permanent structure as the project grows really, really huge.
Okay. Yeah, so we'll take questions. Either you can ping it on chat or raise your hand. Hey, Clarence, I have a question. Now, let's say I already have a private limited company because it is cheaper and I wanted to just experiment and maybe raised a small friends and family round, or I'm the only shareholder in the entity. And now I have interest in moving to blockchain and having its own token and decentralizing it. How do I look at structuring this transition from a private company to a blockchain project?
Okay, this private company, is it based in India? Is that what you mean?
Yeah, for this example, let's consider it's in India.
Yeah, because you see, right, there are issues with the Indian laws regarding this kind of token projects. So that's why for the main legal thinking in this space, right, is that you try and set up a structure as offshore as possible. So in a sense, you try and minimize the connections to India itself. Try and minimize the connections to the jurisdiction where you have the greatest risk of regulatory action. Yeah, so I think that's why in this space, right, some of the more popular structures are like you set up like BVI structures or like Singapore structures or Panama structures. The whole again, right, I think the idea, the concept here is that you see, right, that in a sense there's no real perfect structure, but you try and, again, to borrow a crypto language, right, you try and decentralize the risk as much as possible.
Mhm.
So if in the event that a regulator comes after you, then you can tell a regulator, hey, look, this is basically not your turf because the management and control of the project is somewhere else. So you set up companies in different jurisdictions. Even within those companies, it is ideal to have the board of directors to be from different jurisdictions as well, such that it is not like immediately obvious like where exactly is the management and control being exercised. So in these kind of situations, you can create more defenses when the regulator comes after you.
Got it. So, like you rightly said, you reduce the risk as much as possible until there's more certainty.
Yes, correct. Yeah.
So
Yeah.
we have a question from Amit. What are your thoughts on round tripping? A friend who incorporated in Singapore had troubles exiting due to the same. I'm not sure if the question is fully clear. If not, we can ask him to also come up and speak.
Okay. On this round tripping thing, right? I suppose it's quite difficult to say without having the benefit of the detailed documentation and what's going on. But I would say that if projects are properly structured such that it is such that you are clear which entity performs what role, and the intercompany relationships and documents are clear. So every time there's a payment, there's some sort of document or invoice justifying it. Every time there's a payment to an advisor or whether there's a payment to an internal company, as long as there is some clear documentation, the courts usually will respect this kind of structure in the absence of like very serious fraud type situations. So that's why I'm not entirely sure what was the issue there that led to this round tripping outcome or round
So
tripping.
let me just elaborate on the question. So many of the Indian startups, they would look at incorporating in Singapore, but their entire development team would be in India. They would raise funds in the Singapore entity and end up directing all of those funds, to pay developer salaries and perform all other activities within India. Now, will this be considered as round tripping by the RBI? And if or would it not? And your thoughts on the same?
I can't say affirmatively for Indian laws, right? But I don't believe this actually constitutes round tripping, because round tripping usually refers to some sort of like sending money around within the group. for no real legitimate reason. That is the definition of round tripping. So in the situation that you have just described, right? I mean, is that basically it is a non-Indian company that hires Indian developers or Indian consultants to do work.
But it's held by the same promoters. So the Indian company belongs to the same promoter, and the Singapore entity also belongs to the same promoter.
Yeah, you see, so you see, right, one of the ways to mitigate this kind of concern, right, really is back to what I mentioned, regarding decentralization. So in order to avoid that kind of outcome, right, it's usually best to have as decentralized a management board, as decentralized a shareholding as possible. So I think that the best kind of outcome is that I guess make international friends, have like project team members from different jurisdictions who can also step in to play the role of directors, play the role of shareholders. So in that way, right, it is not exactly the same people who are holding all these assets.
Got that. Thank you.
Yeah, welcome.
Yeah. Thanks, Amit. We have a question from Jatin. When raising your first round, how can an investor be guaranteed that the project will give them the tokens, as smart contracts are not yet legally enforceable?
On that, right, smart contracts are actually legally enforceable, I believe, under most of the laws that have considered this specific issue. Yeah, I think the legal status of smart contracts is that these smart contracts are usually backed by some sort of paper documentation as well. So the thing is that what exactly when a court looks at a particular problem, right, they will consider all the factors. So the smart contract needs to be considered in light of the paper contracts that are being signed as well, because agreements they do not need to be because because when you refer to like agreements or contracts in like the general sense, right, these are all like physical paper documents. But legally, right, when the court is trying to figure out like what is the arrangement between two parties, they will consider more than just the physical paper. So like, for example, verbally, what you say, what you promise, the physical paper is the most important evidence, of course. And they will also look at the smart contracts as a whole to try and figure out what exactly is the relationship between the parties. So as long as there is a clear intent that the investor intended, that the project intended to give certain tokens to the investor based on a certain vesting schedule, and the project party did not deliver, then there is actually a clear legal case in these kind of situations. Yeah. So I think you don't need to be so worried about that bit.
Got it.
Sorry. One more caveat, right? Usually when courts consider the circumstances, the stronger evidence you can present, right, is some sort of paper contract. So I guess that's where lawyers are important to come in to really write the contract properly, to protect, to write a fair contract that protects both the project party as well as the investor.
Got it. So you have this smart contract, and then you consult lawyers to translate that into a legal contract that both parties can enter.
Yeah, the smart contract right now, because you see, right now, I think there's like a lot of work being done on the Ricardian kind of smart contracts. I don't think we're at that level yet where the smart contract is an actual legal contract. So I think the way to view it is that the smart contract is sort of like ancillary evidence to the main paper contract still right now.
Great. So we'll take one last question from Mayur. Can a startup convert equity held by investors to a token in an effort to decentralize the project? And if so, how?
Yes, that is actually okay. How do I say? There is no, because equity and token are very different things, right? Equity is shares, ownership shares in a company. Tokens are like some sort of widget, some sort of Nike shoe that you're selling. There is no direct conversion process per se. Yeah, it's like because a share is a very different creature from a token, right? There's no direct conversion process. But what usually happens is that when investors come in, they will sign some sort of note that allows the investors a certain amount of tokens and also a certain amount of equity in the company. Yeah, so this note is quite a flexible note and can be customized according to the exact intention of the parties. So like, for example, right, if an investor comes in, they say, hey, I want 5% of equity of your company. And if you issue tokens via any sort of affiliated entity, we also want 5% of the token supply that's being issued there. So in a sense, that is how the equity, quote unquote, gets converted. It's all a contractual relationship.
Great. I think there's one more that's a very general question. How do Singapore investors see India as a crypto?
Oh, sorry, how do Singapore investors what?
How do Singapore investors see India as a crypto? But I'm guessing it's talking about as a crypto market. How do Singapore investors see India as a crypto market?
I would say, I would say that most investors around the world see India as like a huge growing market with a lot of potential, because you see that there are so many new projects coming up every day. There's so many like creative minds in the space looking to do creative things. Yeah, so I think they are actually very they actually view Indian projects very favorably. And in fact, from what I see as well, right? I mean, like the quality of the white papers that are coming up, the clarity in thinking, I myself, I view Indian projects very favorably as well, because I think many of them are out there to solve very real problems in the space.
Great, fantastic. Thank you so much, Clarence. This was very useful. You would have saved a lot of people a lot of money in consulting fees as well by attending this talk.
Yeah, welcome. Yeah. So I think the main thing really is again you can apply the concept of decentralization to the legal structuring. That there's no real perfect structure out there, because each structure has a set of trade-offs. But if you follow if you follow the lines of like whenever there's a query, right, you think how best can I decentralize this to minimize my risk, segregate the risk, decentralize the risk, then I think you should be in good state for the structuring.
All right, fantastic. Thanks to everyone who's asked questions, and thanks again to you, Clarence.
Yeah, welcome. Yeah, thank you for having me. Thank you.
All right, see you.
Thank you.